Okay, so Mr. Segura, when you were here and entered your plea of guilty, I asked you some very specific questions about pleading guilty freely and voluntarily, and then pleading guilty because you actually did what they charged you with, and your answers to both of those were yes. The version, however, that of your version that I received here in the pre-sentence report is a little different. It says that...
The judge has already spotted a problem. During his guilty plea, the defendant admitted responsibility. But now, his version of events sounds completely different. In court, consistency matters. When a story starts changing, judges immediately start looking for cracks. And this judge is about to start digging.
You didn't have the drink until your vehicle was stopped. And so your version, if I'm to believe it, is that you stopped at the Taco Bell.
Yes, ma'am.
You drove to the Taco Bell.
I drove to the Taco Bell.
You stopped at the Taco Bell and you drank while your vehicle was stopped.
No, ma'am. I was outside the vehicle when the officer.
So you hung out at Taco Bell.
Drank. I was waiting for the line to move so I could get my food.
I asked that the defendant be sworn.
Yeah. Let's do that. Raise your right hand. You swear or affirm that the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
So help me God.
Okay. So you're saying that you got to Taco Bell. You drove to Taco Bell.
Yes, ma'am.
Okay.
I made a right turn with my signal and everything. Then I was about to park my vehicle. Mm-hmm. That's where the swerve came in at. Okay, obviously it has to be. And then so
I'm not worried about. Hold on.
Yes, ma'am.
All right. I want to know, when you got to Taco Bell, regardless of whatever happened,
right?
Did you go through the drive-through or did you park?
No, ma'am. No, ma'am.
Listen to my question. Did you go through the drive-through or did you park?
I parked.
Okay. So when you parked your car at Taco Bell, you start having alcohol at that point?
No, ma'am. I got out of my vehicle to see how far traffic was up in front of me.
Okay.
They had several cars in front of me.
In front of you for what? You were parked?
Yeah, I was parked like.
Were you parked in a parking spot or were you parked in the drive-through?
I was not exactly in the drive-through. I was at the end of the store. At the end of the store.
Okay.
But I guess you could consider that the drive-through line.
Were you waiting for the drive-through?
I was waiting for the drive-through to
okay,
proceed.
Listen, here's the thing. You're not going to try to trick me up with semantics today.
No,
hold on.
Did you catch that? The judge isn't getting hung up on technical wording. She's laser focused on the facts. This is a classic courtroom moment where a witness tries to answer a different question than the one being asked. Judges see this all the time, and it's one of the fastest ways to lose credibility.
Don't talk over me.
Yes, ma'am.
When I say, were you going through the drive-through or were you parked? What does that mean? That means, did you park your car because you're going to go in the store, or were you waiting in the line to go through the drive-through?
I was actually waiting to go through the drive-through.
Okay. I may look, I don't know, like I'm 12 years old and just fell off the turnip truck,
ma'am.
But I'm not.
No, ma'am.
So you're in the line and you get out of your vehicle, right? Because there's a long line. Right. The cars aren't moving.
Right.
Right. So you get out and you decide, I'm going to start drinking here in the parking lot.
No, ma'am. I didn't drink until I got back inside my car.
Okay. But while you were at the Taco Bell, you started drinking. Had you drank before that?
No, ma'am. So
you're telling me that you started drinking at Taco Bell?
Yeah, I opened the container. That's how the beer came. It was on the floor.
So from the time that you started drinking at Taco Bell to the time that the officers got there, about how long was that?
Oh, maybe 15 to 20, 30 minutes, whatever.
Okay. How much did you drink between that time?
I had a malt liquor. The 211 is a strong beer. Mm-hmm.
Just one?
It was a 40 ounce.
Right. So you drank the whole 40 ounces.
I was drinking out of the thing. After the fact that
you were drinking out of what?
After I stepped back in the car, I started drinking it.
Right. So how much of it did you drink?
I consumed a lot of it.
Okay, so let's just say you drank most of
1
40 ounce
If it was, can it contain this?
So that's your story and you're sticking, hold on. So is that your story and you're sticking with it, that you drank most of 1 40-ounce beer in about 15 to 30 minutes and that you hadn't drank anything before then?
No.
Now the timeline becomes critical. According to the defendant, he drank most of a 40-ounce malt liquor in roughly 15 to 30 minutes after arriving at Taco Bell. The problem? Blood alcohol evidence doesn't just disappear because a story sounds possible. The judge is already comparing his explanation against the science, and that's a battle defendants rarely win.
Except for that night before, about 2 o'clock that morning.
Okay.
And then whole blood, alcohol stays in your blood system, added to what I drank.
Okay. So your test on this night after drinking most of a 40-ounce was 0.188. And you're wanting me to believe that that's based on most of one drink, and that maybe you still had alcohol in your system from the day before.
Yes, ma'am, but what I recalling my memory, ma'am, I have no reason to try to trick you, Miss West. I'm telling you the God's honest truth. Like I said, I had alcohol in my system from the night before.
Well, how much did you drink the night before?
Well, I was intoxicated.
So what you're telling me then, if you had, hang on, so if you had that much alcohol in your system from the night before, that you were still probably hold on. Watch where your story's going.
Yes, ma'am.
So you're telling me you had so much in your system the night before that it was going to still be in your blood, and you had just driven to the Taco Bell.
No, I drove into the Taco Bell later on that evening.
You're not right.
But it wasn't a full 24 hours.
Right. So if you're saying that 0.188 is because of the night before, then all likelihood you were drunk when you were driving from the night before, if I'm to believe your story that you only had most of one drink while you were there. See how that doesn't make sense?
Yes, ma'am.
Okay. All right.
That right there is a devastating piece of judicial logic. The defendant is trying to explain his high blood alcohol level by blaming alcohol from the night before, but the judge flips the argument around. If that's true, then he may have already been intoxicated when he drove to Taco Bell. Either way, the explanation creates more problems than it solves. Did you see how quickly she cornered him with his own testimony?
So let's go back. Obviously, there's some medium acceptance of responsibility, so we can go forward with the arguments unagreed. Mr. Mr. Coleman, you have a witness?
Yes, Your Honor. State Cost Troy Robinson.
Mr. Robertson, if you please raise your right hand, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may proceed.
Your Honor, the court's familiar with Mr. Robinson and his background, but
Sure.
for the purpose of the record, Mr. Robinson, you're certified as a fingerprint expert. Isn't that correct?
That's correct.
How long have you been certified as a fingerprint expert?
Almost 6 years now,
Testified in court before?
multiple times.
You've had an opportunity to review some documentation in this case.
I have.
Did they include prior judgments for the defendant, Mark Anthony Segura?
They were.
I'm showing you what's been marked as State's Exhibit Number 1. Is State's Exhibit Number 1 a fair and accurate summary of the 20 previous felony judgments that you reviewed in this case?
It is.
Using your
for 20 felony judgments.
20 previous prior criminal judgments, including a number of felonies.
Correct.
Okay. In other words, both misdemeanors and felonies.
Yes, sir.
And did you use the defendant's admission to at least one of the DWIs that he pled true to that had a print on its judgment to compare to the judgments here that had prints on it?
That is correct.
And what was your determination?
They're the same person.
And in addition,
Just when you think this hearing is only about one DWI, the prosecution unveils something much bigger: criminal history. And not just a little history. An expert witness is now connecting the defendant to a long list of prior convictions. This matters because sentencing isn't just about what happened today. It's also about patterns of behavior over time.
addition to the prints that you use to compare and confirm his identity on these judgments, were there also some personal identifying information such as date of birth, SID numbers, and that kind of thing that you use to link to?
Correct. It's known as death card.
Okay. Your Honor, at this time, I would offer State's Exhibit Number 1, which is a summary of the judgments, and the actual judgments themselves that are marked as State's Exhibits 2 through 20. For purposes of the record, tender to defense counsel.
Let me just ask, are there any on that list that aren't already on the pre-sentence report? I mean, why are we
It's
doing
been a while
both?
since I looked at it, Judge. I did think that there was at least a couple of those judgments. It's been a while since I looked at it.
Mr. Burbank, does your client,
I'm gonna,
hold on, does your client have any objection or any reason not to, for me not to take judicial notice of the PSI for sure, that those prior offenses listed in there and the ones that are convictions are any way wrong?
for the misdemeanors, that's correct.
Okay, so what about for the felonies? Is there one, are there one or more that are, he contest?
It's catch-22, Judge.
Okay,
He's pled not true to them so that you'd have the full range of punishment.
oh, okay, so,
Yeah, so it's the two felonies that I think are crucial here.
all right, so then do you have any objection to the states, was it 1 and 2?
Judge, it's, State's 1 is a summary.
I object to states 1 because I was not given the misdemeanors.
Okay, my main concern are the felonies. And if you have the actual judgments on those, why don't we do that way, even though it might be a little more documentation, Mr. Coleman? If you will go through primarily the felonies would be my concern.
Yes, Judge.
And,
Here's where I'd like to do, Judge. I'd like to admit the summary.
Okay, my main concern are the felonies. And if you have the actual judgments on those, why don't we do that way? Even though it might be a little more. Documentation, Mr. Coleman, if you will, go through primarily the felonies would be my concern. Yes, Judge. And here's where I have to object, Judge. I like to admit the summary and just the felonies as a backup because what I want the court to refer to is the summary. I want to talk about the summary. Well, I want to talk about, I've got the presence report, so I need to know if there's something in the summary that's not in this report. That's what I'm kind of used to looking at. I've already made my notes on it. I got highlights. So if there's something that's not on that already, let me know. If there is, then obviously I will. So are that there are 19 misdemeanor convictions on the presence report and that I've got 8 felony convictions. I think I don't have 8, Judge. I think that there's at least one of them that was refused. If you refer to the PSI, that first one, burglary, it looks like it was refused. I have stopped. Don't. Let us figure it out. Yes, ma'am. So what I show with convictions on the PSI, I've got a 91 possession of a controlled substance. There was a probation that was revoked for 5 TDC. Yes, Judge. And